we're going to be talking about lease agreements and the importance of having one. So the first thing I'm going to say about lease agreements, if you don't have one, get one, have one. Never rent out a property just word of mouth, because things could be misunderstood. You forget to mention certain things. People will forget what you said. So lease agreements are very important. If you don't have one, then you're putting yourself in a high risk situation. And the main thing about a lease agreements are the terms. So Sam, when we're thinking about terms, what do we mean and what are we talking about?
Well, first off, especially if it's your friend or family member, have it in writing.
Yeah, especially if it's family that's involved. Yeah, I have family that rents from me, and we have a full lease agreement.
I can speak mainly from the perspective of California. The basic terms are going to be the duration, whether it's a 6-month, year, multi-year, or from month to month. The second basic portion of the lease agreement is the price. How much have you set the rent to be, right? It has to be in writing. So that way there's no ifs, ands, or buts about it. And then with anything, when do you expect to get paid? The beginning of the month, middle of the month, end of the month? I've had lease agreements for the 21st of the month. Believe it or not, I've had lease agreements for the 15th of the month. So it all depends on the lease agreement. And then with that, how late can the payments be before it violates the agreement? The kind of the standard is 5 days, given a weekend, a Saturday, a holiday, whatever the case may be, where the bank is closed for most people. So there's always a 5-day grace period. But within the terms, there's more detailed terms that you need to know about, and a lot of it is state specific. So depending on where you're investing in or you have your rentals at, you have to make sure you know the landlord tenant agreement laws there. But my lease agreements have grown over the years. It used to be 1 to 2 pages. Now it's 16 plus pages long.
Wow.
And I have heard of people's lease agreements at 40 to 60 pages long. So it just kind of goes to show you what it is. It's your first line of defense when it comes to any disagreement. It's your lease agreement. So
let me ask you this question. You said something very interesting, Sam. You talked about how the payment, for example, you said you can determine on the lease agreement when the payment is due, because most people think about, oh, it's the first of the month, the rent is due. But so why would you set up, or why have you set up different payment dates for the rent?
Well, let me give you some example. So traditionally, they do the first of the month, right? And traditionally, you have a 5-day grace period. So if they pay on the 1st, the 2nd, the 3rd, the 4th, the 5th, they're on time. However, sometimes people move in the middle of the month. And sometimes people don't want the proration. They just pay from that point forward because it's easier for them. You as the landlord, you can do whatever you want, but if the agreement is, okay, you came in on the 21st and you'll count that as your first day of the month you're staying in these terms, then every 21st it's due. So I've had that before. I've had it where it wasn't because I had set it up that way, but I inherited a tenant who basically argued and showed evidence and proof based on her original lease that she did move in later, and that's how they charged her through a verbal agreement, and she showed me receipts of deposits, so I had to just keep that up. Another one was because of the payment schedule of the tenant. I had a tenant where their payment schedule is as such that they have the bulk of their money on the 15th of the month. And so I agreed that the rent will be due on the 15th of the month. So that's all up to you, and it's between you and your tenant. Make sure it's spelled out on the lease, though.
Okay, excellent. All right. What else? What else do we have? What about, you mentioned violations. I think you talked a little bit about that.
Oh, yeah, violations.
So talk a little bit about when you have to be hardcore or should be about a violation, and when you can work with the tenant. How does that happen?
So, within your lease, you have a lot of conditions, right? A lot of rules set forth that you create. Some of them are standardized, and you can deviate as you want, as your property. Everything from subleasing, breaking the lease, how long for a notice, trash in the backyard, trash in the front yard, what's allowed to be hung in the windows. I know it sounds, ticky-tacky, but that's very important because the presentation of your property is how attractive it is for the next tenant. And things can grow legs really fast. So you have to make sure you have it on the lease because it becomes an item of dispute if you don't. So I have all that on my lease.
Okay.
At the end of the day, though, we're all human. And a lot of this is to protect you. But you also know that based on a person's socioeconomic condition or cultural background, certain things you can empathize with, and certain things it's more or less the spirit of the law versus the letter of the law. In this particular case, is it a curable violation, an incurable violation, or something that's very gray that you can allow to kind of swing a little bit one way or the other before you take any enforcement? And I'll give you an example. Trash, right? Or items. I put on my lease that in the yard, they can't have any furniture, they can't have anything like that. And the reason for that is because it has to do with the code enforcement of that city. That city tells me that I can't have these things in the front yard. So therefore, it's in my lease. The city's spirit of this ruling is because they don't want people to have trash and bulky items piled up, specifically like gas cans, old tires, rims, engines, motors, junk cars, you name it, I've seen it.
Yeah.
But the way they put it is you can't have any of these permanent items and trash in the yard. Well, for example, a table and 2 patio chairs, that falls under that condition. However, you have to kind of exercise caution as far as how strict you want to do it. If it's a nice table and nice chairs and they just sit out there to chat and have a cup of coffee, that's different than a torn up, tagged up chair sitting out in the front yard, or a couch that's torn and moldy sitting out there festering and basically inviting riffraff.
Right.
So that's where it becomes discretionary and exercise kind of some restraint in how you enforce it. But if you have multi-units, you got to remember, word of caution, whatever you enforce it across the board, be fair. Right. Now, there are things that are incurable, right? So, for example, if they were to do a major alteration to the place, or here's my biggest violation that I've seen and I've dealt with, subleasing. It's in my lease. You cannot sublease the unit. The unit is for you and the people on this lease. But a lot of times, if you invest in class C minus, D minus neighborhoods, you're going to get a lot of folks who bring in outside family members, extended family members, co-workers to live in there. To me, that's incurable. I normally give them a 3-day notice to get the people out.
Okay.
After the 3rd day, I go and do a final check. And if they're not out, I evict, period.
Wow.
And the reason why I choose to do that is because I don't want it to linger on and get to the point where now, although they've already established residency, but now they're going to begin to establish permanent residency with my knowledge, and I have to battle in court with it. So I evict pretty quickly on that. So that's another thing. But all this is in your lease. How many days do you, the landlord, have to refund the security deposit after they move out? That's in your lease.
Excellent. Yeah. So let me ask you this. What about, do we have, or have you done it where on your lease agreement, you include what the rent increases will be, or do you not include that to just kind of guard against what market conditions may become? What's your take on that?
Oh man, that's a tricky question.
Yeah.
So I have done it before. I've done it, in fact, twice, and I regret it.
Oh,
and I regret it because just like what you said, if you put it in writing, it's in writing. And as you know, recently we've had 8-9% increases in devaluation of money or inflation, right. And you can't go back and redraw up the lease, right? They have something in writing that says you agree that you're only going to do a 3% increase or a 5% increase. So now I leave it open. I have done in the past for multi-year leases, like 3 to 5 years. I've had built-in 3% increases, but I don't do that anymore. Now it's what I call, I reevaluate the operational costs, and I send a letter out every 6 months. Believe it or not, I do a 6 months reassessment of the apartment's costs.
Okay.
Not necessarily raising people's rates, but letting people know that I'm actively reassessing every 6 months. Where in actual practice, every year or 12 months, I do tend to raise the rates, even if it's a little bit. And I think that's good practice for you as a landlord, because let's just say you're getting pretty good rents and you're very comfortable, you're making your profit. A year goes by, 2 years go by, and you don't increase the rents. And all of a sudden, inflation hits, like what we just experienced the last couple of years. And now you're trying to catch up. It's easier to swallow when they know the common practice is a rent raise. And it's easier to swallow $20, $40, $60 than it is $300 all at once.
Right.
So I would suggest maybe a $20 increase if nothing is happening, because at the end of the day, it covers your incidentals for a water leak, for this, for that. And that I would highly suggest it.
Excellent. So yeah, so that's such a great point right there. The point that you don't want your tenants to get used to not having rent increases.
Yeah.
But also by the same token, if you're able to put in these little incremental increases, when you do have to increase the rent a little bit more, you actually won't have to, because you've already been doing it for a little period of time.
Yep.
Maybe instead of doing that 8% increase, it becomes maybe a 4% or a 5% increase. And that's easier to swallow. Excellent. So what about the eviction process? You mentioned the eviction process. And sometimes, and of course, the eviction is going to be based on your lease agreement, because so long as your tenants are not violating that, you're locked in for that lease, assuming that you have a lease agreement. So here's the first part of the question. When you're doing a lease agreement, do you rather do, let's say, a month-to-month agreement, or would you rather do, 12 months, 18 months? You mentioned right now you've done up to 3 to 5 years. What is your preference and why?
So over time, with experience, I have come to rely predominantly now on a month-to-month agreement.
Interesting.
I have had tenants ask me for a year lease, and I've turned them down. No, I'll find some other tenant. I won't do a year lease any longer. That's based on experience, but it's also based on California. So I invest in California, knowing the court's view on landlord-tenant relationships. I believe that the month-to-month protects landlords better. And it also protects the tenants more too, because it lets them get out pretty quick. But for the purposes of this podcast, we as investors, for California, I believe the month-to-month is the best.
Excellent. Okay. And then if a violation actually occurs where you have to evict the tenant, and I'm not asking you, Kip, to outline what the eviction process is, but my question really is, do you include any of that information in the lease agreement, or is it more of the type of thing where it's up to the tenant to understand what the laws are in relation to renting and a tenant, the owner and tenant relationship? Where do you land on that?
So I include that in the lease.
Oh, you do?
I actually put a line in the lease specifically for that. And I also outlined that if I were to sell the property, right, I have the right to kick out the tenant, or amend the lease, if you will, cancel the lease. If I have family members or I want to occupy the property, I have the right to. If there are major constructions that need to occur, I have the right to ask them to leave and to complete that construction. So that's all within my lease. Some people might not ask or put that in there because they expect that, hey, when that time comes, the law is going to be on their side because it's written in the laws of the land. But I think that it's good to talk about it ahead of time, up front with the tenants, so they know their rights as well. Because sometimes tenants don't know.
Right.
Not every tenant stays up with tenant, rights. They have this general expectation that, okay, I pay my rent on time, I got a place to stay, right? But that's not always the case. For example, nuisances. I speak with the tenants about nuisances. Don't be making noise after 10:30, 11 o'clock at night. Because if I get a complaint from your neighbor and this complaint is constant, or if I get a phone call from the police saying that someone on my property is making noise, causing a nuisance, that's a violation of the lease. I have the right to evict you. I might give you a chance once or twice, but just like late rents, they may pay your late fee. Let's say, for example, you have a $50 or $75 late fee, but they're late 4 times a year. Do you really want that? Some people say, oh, no, you got to make a little extra money. I look at it as this is an unreliable tenant. So you can't evict based on the pattern of paying the rent late, even though they pay your fees. And so that goes to the other side. Just like the lease, every time there's a violation, make sure you document it. It's a quick 1 page. Hey, you violated the lease. Cure it. Here's how you cure it. Send it out certified mail. Keep a copy for yourself. Boom, you're done. You have basically established a paper trail of misconduct, if you want to call that, right? And that way, when a person wants to challenge you in court, you can present to the people, the judge, to take a look at what you're dealing with, and hey, you've got your record keeping, and it's good practice.
Right. I would add to that, and that's all great information. I mean, that's pretty amazing information you're providing us there. But I would add also that, and of course, this is because you're able to, on a number of your properties, you're able to self-manage those properties. But what I would say or add to that is that when you're using a property management company, make sure that one of the things you're going to ask them is, let me see a copy of your lease agreements, because they're the ones that provide the lease agreements. And go over that lease agreement with them. If there's something that's not there that you need specifically because you know it works for you, have them add it to it. Or by the same token, if there's something that you're thinking, I don't really want that for whatever reason, absent it being a legal requirement, you can also ask them, is it okay if we just remove that? And I'll take that on as my added risk. So make sure that you discuss this with your property managers so that they understand how you're thinking about how tenants need to be managed.
Oh,
So
I agree with that absolutely, and I've dealt with that. I've had property managers who have been successful for many decades, but I like to standardize my apartments. So when I meet with the property manager, especially one that's an in-place or an on-site property manager, I actually created a little packet. I created myself just over the years, right? I have a template of the lease I want everybody to be standardized to. I have a template of all the different violations. All they need to do is put the apartment number and the name, the date, and whatever the case may be. I give them blanks. A template of my background paperwork that I require. And I say, here, make copies if you want to, but there's 10 copies of each.
Right.
Have at it. And if you have any questions, give me a call. In fact, I go above and beyond in the sense that I'll give you an example. Recently, I closed on a building about a month and a half ago. I went in and I redrafted everybody's lease. I got a copy of their lease, and some of the leases were only about a month old, but it doesn't matter. As a new owner, I wanted to be standard in the sense that I know what's in the lease and I can pick out what I need to pick out when there's a violation right away. So I just rewrote everybody's lease, met with every tenant and have them sign over. And then that way I got a chance to let them know where I stand and what my expectations are of the tenant, and let them know what their expectations should be of me as the landlord and what I expect of the on-site manager. So that's how I do it.
Right. And you know what? That's excellent advice. And the reason I say that also is because we have to keep in mind that these lease agreements, they are legal documents.
Yeah.
And I like the fact that you said that you'd like to keep them standardized across all of your properties, because obviously you're the one, if ever you have to go to court, you're the one that's going to have to be able to speak to that lease agreement. And if you've got a lease agreement there that is foreign to you, that you weren't part of, boy, that can trip you up quite a bit. And you could end up losing on the losing end of that situation.
Exactly. So that's exactly why.
So that's a great piece of advice. So I hope our listeners understand that again, it's a legal document. At some point in time, the bottom line, this is a business, and we're in the business to provide a good product, a good service, but also to make money, obviously. And every now and then, that means that you may end up having to go to court, and we'll probably do a little a presentation or a podcast on the legal aspects, although this is kind of touching on it. And the first thing to do is to have all of your paperwork in place, because when you go to court, you might get subpoenaed. Well, let me see your lease agreements. Let me see any other documents you have. Let me see this. Let me see that. And if you have everything squared away and in place, it's going to make your case that much stronger.
Yep.
So excellent. Hey, great discussion on lease agreements. I hope our listeners picked up a few tidbits out of that. Any final words here, Sam, before we
No, as usual, we provide all this education for free. Hopefully it gets people thinking, get people investing. But if you like what you see, we hope that you hit that like button, share this with your friends, and let us know what else you want us to talk about. Send us a quick email, realestatehedgehog@gmail.com. Let us know if you want to get into our newsletter. We put out a newsletter once a week, usually comes out around Sunday or Monday, with even more information, more detailed ways, but also our journey from week to week and what we're doing to grow our own personal wealth.
Excellent. All right, Sam. Well, thank you so much, buddy. We'll talk to you soon enough, and we hope that we can see all of our viewers sometime in the future. Take care,
Sounds
everybody.
good.